The difference between a tragic accident and a criminal offense is the application of state power. A homicide conviction demands an unbroken line of legal attribution, a precise link between a defendant's specific conduct and the cessation of a human life. This timeline maps a classic criminal law problem. A defendant pushes a victim. The victim hits her head and falls unconscious. The defendant walks away, abandoning her. Later, a fire breaks out in the building. The victim is rescued, but severely burned. At the hospital, a doctor administers palpably negligent treatment, and the victim dies. With multiple actors, an abandonment, a fire, and medical malpractice, all contributing to the death, pinpointing who is legally responsible for the homicide requires untangling a dense chain of events. The foundation for establishing that liability rests on a Latin maxim, Actus non facit reum, nisi mens sit rea. As Lord Hailsham summarized the doctrine, an act does not make a man guilty of a crime, unless his mind be also guilty. For this analysis, we are setting aside the guilty mind, the mens rea, entirely. We are isolating the actus reus, the guilty conduct itself. Resolving complex homicide scenarios means ignoring moral intuition. You have to apply a strict architectural framework that maps out conduct, duty, and causation. This diagram breaks down the actus reus. It is frequently translated as the guilty act, but that definition is incomplete. Actus reus encompasses everything in the definition of an offense, excluding the defendant's state of mind and any possible defenses. It is built from up to 3 components: an act or omission, specific surrounding circumstances, and sometimes certain consequences. Looking at Section 1.1 of the Criminal Damage Act 1971, the requirement that a person destroys or damages property is the consequence. The requirement that the property is belonging to another dictates the necessary circumstances. This creates a legal distinction between offenses. In conduct crimes like perjury, the physical act of lying under oath completes the offense, regardless of the trial's outcome. In result crimes like murder, a specific consequence, death, must physically flow from the conduct. Then there is an anomaly, state of affairs offenses, or absolute liability crimes. Here, no voluntary conduct is required from the defendant at all. The actus reus is satisfied simply by a particular set of circumstances existing. In the 1933 Larsonneur case, a French citizen was deported from Ireland and delivered to the UK by Irish police against her will. She was immediately convicted of being found illegally in the United Kingdom. Similarly, under Section 4 Sub 2 of the Road Traffic Act 1988, sitting completely stationary in your parked car while intoxicated is a crime. You are legally in charge of the vehicle. Ordinarily, a lack of voluntary physical control provides a defense of automatism. Recognizing that absolute liability offenses operate differently prevents a common analytical error. These specific crimes are driven strictly by public policy, prioritizing outcomes like preventing drunk driving over assessing the individual's voluntary action. This logic tree maps the doctrine of omissions. Under English common law, the general rule is severe. There is no criminal liability for failing to act. A stranger has no legal obligation to save a drowning child, regardless of the moral imperative or the ease of the rescue. Doing absolutely nothing only becomes a criminal act if the situation triggers one of 5 recognized exceptions, where the law imposes a specific duty to act. One exception is the voluntary assumption of care. In the case of Stone and Dobinson, the defendants took in an elderly, ill relative. They made occasional, highly ineffectual attempts to wash her and provide food, but she eventually died of neglect. The court ruled by making those minimal efforts, they legally assumed a duty of care. Failing to maintain it established the actus reus for manslaughter. A duty also arises if you create a dangerous situation. In R.V. Miller, a squatter fell asleep with a lit cigarette and woke to find his mattress smoldering. Instead of putting it out, he simply moved to another room. The House of Lords held that by creating the danger, he triggered a legal duty to take reasonable steps to remedy it. Medical professionals hold a contractual duty to act, but the law places boundaries on it. Following the Hillsborough Stadium disaster, victim Tony Bland was left in a persistent vegetative state with no conscious thought. The court in Airedale NHS Trust v. Bland established that a doctor's duty to provide life-sustaining treatment ceases if that treatment is no longer in the patient's best interests. The source of the duty dictates the penalty. Failing a statutory duty, like refusing to stop after a car accident, usually results in a penalty for the omission itself.
Failing a common law duty, like the defendants in Miller or Stone and Dobinson, makes you legally responsible for the resulting consequences. For result crimes, linking a defendant's conduct to a prohibited consequence requires a two-tier causation test. This graphic represents the causal chain, starting with the first requirement, factual causation. The threshold question is the but-for test. In R.V. White, the defendant poisoned his mother's drink, but she died of an unrelated heart attack before the poison took effect. Because she would have died exactly when she did regardless of his actions, factual causation failed. If the conduct does accelerate the death, the courts require that acceleration to be more than negligible, as confirmed in the Cheshire case. If an act speeds up a death by only a few seconds, the law ignores it. The but-for test is an effective initial filter, but its net is too wide. If you invite a friend shopping and they are struck by a car, but for your invitation, they would be alive, factual causation is established, but holding you liable is absurd. Determining ultimate guilt requires a stricter filter. The second gate is legal causation. The prosecution must prove the defendant's culpable act was an operating and substantial cause of the consequence. The defendant's act does not have to be the sole cause. In R.V. Pagic, the defendant used his pregnant girlfriend as a human shield and fired at police. The police returned fire instinctively, killing her. The court ruled his actions contributed significantly to her death, establishing legal causation even though he didn't pull the trigger on the fatal shot. The defendant must also take their victim as they find them, the eggshell skull rule. In R.V. Blau, a stabbing victim refused a life-saving blood transfusion because of her religious beliefs and died. The court held that her refusal did not absolve the attacker. The original stab wound remained the legal cause of death. The only legal mechanism capable of fracturing the established chain of causation is in Novus Actus Interveniens, a new intervening act. This requires analyzing the victim's own actions, third-party interventions, or unforeseeable natural events. If a victim injures themselves trying to escape an attack, the court assesses whether their reaction was reasonably foreseeable. In R.V. Roberts, a victim jumped from a moving car to escape sexual assault. Because her response was proportionate to the threat, the chain remained intact. Only if the victim's action is completely voluntary and daft will it break the causal link. The most complex doctrinal stress point involves medical negligence. In R.V. Smith, a stabbing victim died after receiving thoroughly bad medical treatment at an army base. Lord Parker, Chief Justice, ruled, if the original wound is still an operating and substantial cause at the time of death, the chain is unbroken. The definitive modern test was cemented in Cheshire, where a gunshot victim died 2 months later from a poorly managed tracheotomy. The court ruled that negligent treatment only breaks the chain if it is so independent and potent in causing death that the defendant's initial act becomes insignificant. Despite lay assumptions, medical negligence almost never breaks the causal chain in modern law. It is a frequent trap in exams. If you put someone in the hospital, you carry the legal risk for the subsequent failures of their treatment. Returning to our initial timeline, the defendant pushes the victim, who falls unconscious, is caught in a fire, and dies after negligent medical care. Applying the but-for test, but for the defendant knocking the victim unconscious, she would have escaped the building. Factual causation is established. Under the Miller Doctrine, knocking her unconscious created a dangerous situation. This imposed a legal duty on the defendant to take reasonable steps to help. By abandoning her, the defendant committed a culpable omission. Next, we analyze the intervening events. If the building fire was a highly unusual, unforeseeable natural disaster, it might break the chain. But if it was a foreseeable risk of leaving someone helpless in a hazardous environment, the chain holds. Finally, we apply the Cheshire test to the doctor's palpably wrong treatment. Was the doctor's error so exceptionally potent that it rendered the initial head trauma and burn injuries legally significant? Based on precedent, it is highly unlikely to break the causal chain. In high-stakes law exams, the final verdict matters less than the reasoning. The objective is demonstrating a rigorous, sequential application of the architecture, isolating the conduct, verifying the duty, and stress testing the chain of causation.